Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. We have another new filing in the Justin Baldoni versus Blake Lively universe, as the New York Times has given their response, and this is involving their motion to dismiss Justin Baldoni's complaint. Justin Baldoni's side had a chance to respond to that, and now the New York Times gives their response. We're going to go through that together. And then after that, I'm actually going to go join my friend Omar, the Tilted Lawyer, on his stream. We'll be talking about some of these filings and his kind of legal takes on those things. So I'll give some people a second to kind of jump in here, and then we'll start reading. But so this is now fully briefed, which means that the judge, since the New York Times has given their response, now the judge can rule on this. It'll probably take a little bit, but they can actually... this is actually ready to be decided. So that's, I know Justin's side will probably want to file an amended complaint. So hopefully the judge will allow them leave to amend, but we'll see. What is a bombast conspiracy theory? Well, bombast just means it sounds impressive, or it sounds smart, or it sounds like a big deal, but it really doesn't mean anything. So that's kind of what bombast means. So basically they're just saying it's they're just saying this is crap, essentially, is kind of my take on what they're saying here. But we'll take a look at it. Let's don't take my word for it. Let's see theirs. All right. Zoom in a little bit. Don't worry, this one isn't too long. It's only 10 pages. All right. The New York Times Company, The Times, respectfully submits this reply memorandum of law in further support of its motion to dismiss the consolidated plaintiff's first amended complaint. It is easy to overlook in all of plaintiff's bombast and spinning of conspiracy theories that only a single statement is at issue: that plaintiffs orchestrated a smear campaign against Lively. As the Times has made clear, however, this statement is absolutely privileged as a fair report under New York Civil Rights Law 74. And even if that were not so, plaintiffs have not come close to adequately alleging that the statement was a knowing falsehood under the actual malice standard, or shown why the characterization is a non-actionable opinion. But the broader stakes are worth remembering. The Times did what a news organization should do. Oh, no, it didn't. Okay. It reported on serious allegations of wrongdoing. It did so by covering accurately and fairly, okay, Blake Lively's complaint filed with the California State Agency, and by, not surprisingly for conscientious journalists, doing supplemental reporting on the allegations and reaching out to plaintiffs and publishing their response. That's ridiculous. We all saw what happened. We've seen their emails that they included an attachment in their motion to dismiss. And what they did, maybe it's what news organizations do, but that's why people are so pissed off with news organizations, because the way they conduct their business is fucking wrong. It's garbage. All right. So they make it sound like they reached out and they gave them a chance to defend themselves, but not really, right? Because it was the weekend before Christmas. They emailed them at 9 p.m. or something like that. And then they give them until noon the next day, I think it was. And most of that was sleeping hours. And again, people are traveling for the holidays and shit like that. So wow. Gosh, so gracious of you guys. Okay. Whatever. Were plaintiffs to succeed in their misguided effort to recast acts of journalism as civil wrongs, the losers would be the public. Fuck you. No thanks. I reject that, but okay. The losers would be the public, which depends on the press to do research and to report on government proceedings and to cover controversies of legitimate public interest. I don't depend on these people to do jack shit. I don't trust it. Not anymore. That, of course, is why the law broadly protects the press from the kinds of misconceived legal attacks that plaintiffs make here in the hope of silencing voices they would prefer not to hear. Well, if only that were possible, then I wouldn't be reading this. But since I want to cover all sides, of course I'm going to. Even if I don't agree with it, we're going to go through it anyways, because that's the right thing to do, in my opinion. It's to make sure to at least hear out all sides. Okay. 1 argument, New York law applies to plaintiffs' claims. Plaintiffs spend pages of their opposition explaining why California law applies to this matter. The Times believes that dismissal is appropriate under either state's law, but the weight of the relevant authority, which plaintiffs make little effort to distinguish, makes clear that New York law applies here. Plaintiff claims that California law must apply because the article is about residents of Hollywood. That is the same argument that was rejected in Jacob, the case that they cited up here. Okay. Jacob, okay, so they argued that California law applied because of the rise of the influencer industry was based in LA. Okay. The court properly saw that because the Times is a New York paper and its journalists need to know what privileges will protect them at the time they are deciding whether to publish. New York applies. Plaintiffs also argue that, unlike the plaintiff in Jacob, they never affirmatively alleged that the reporting emanated from New York. That is false. They allege that the Times and Lively worked hand in glove to publicize Lively's allegations. Plaintiff also alleges that both the Times and Lively are located in New York. In short, New York law applies. Okay. B, plaintiff's defamation claim fails. The article and video are absolutely privileged. The Times, working from Miss Lively's complaint, reported that plaintiffs orchestrated a smear campaign against Lively. But that's not true, is it? Because they weren't working from Miss Lively's complaint. I've seen the CRG complaint. I've seen the right to sue letter. I've seen the precursor. I've seen all of it. There's no thousands of pages of text messages included in any of that. So it's not exactly what happened. I feel like they kind of shot themselves in the foot. Even if they get off on legal technicalities here, we all know what happened. That is the sole statement at issue, and it is absolutely privileged as fair report of the CRD complaint. Plaintiffs cannot save their case by cherry-picking phrases from the article and the video to construct an argument that the Times affirmed as true the allegations in the CRD complaint and therefore lost the protection of the fair report privilege. Do you really want to talk about cherry-picking phrases? Because Megan Twohey cherry-picked the hell out of everything and made the worst Shirley Temple the public has ever tasted. And now you want to be like, that's fine, the public depends on us. Drink it anyways. No, fuck you. Jesus. I can't stand these people. Give me one sec. Okay. Can't believe these people, not these people talking about cherry picking. Like, oh my God, you gotta be kidding me. Okay. I'm feeling a little mad this afternoon. Okay. Plaintiff's insistence that one or two phrases in the video, for instance, Ms. Twohey's statement that text messages show what really happened, somehow vitiates? Is it vitiates? I don't know. I'm always honest when I don't know what words mean, guys. I don't know what that word is. Let's find out. That doesn't make me dumb. It doesn't make any of us dumb. We just all have gaps in our knowledge, and I don't happen to know all these really strange dictionary words. Spoil or impair. Okay, I got it. Let's see. Okay. Somehow vitiates the privilege, or yeah, so spoils the privilege, ignores how the law actually operates. A fair report analysis requires the court read the challenge statements in the context of the entire statement or publication as a whole. In fact, the New York Court of Appeals has been unequivocal that the language used should not be dissected and analyzed with a lexicographer's precision. The court is to look to the article and video as a whole. Both parts of the Times publication repeatedly inform the reader that the Times is reporting on the CRD complaint. Yeah, but they weren't. They were reporting on a hell of a lot more than what was in that CRD complaint. The video is framed with the introduction in a legal complaint Lively filed on Friday. The article and video refer to the CRD complaint 6 times, uses the words allegations and claims 11 times, links to the CRD complaint embedded in the article, and includes plaintiff's vehement denial. Taken as a whole, any reasonable reader would understand would understand the Times to be reporting on the allegations in the CRD complaint, not offering them as fact. You know what? Hold on, guys. Don't take my word for it. I'll show you where to find the CRD complaint. I'll put a link in the chat right now, and you can go through it yourselves and see. There were not thousands of pages of text messages attached to that. And they said that they verified through looking through thousands of pages of text messages. So that was either a lie or they're lying about the resources that they used to do their article. Give me 1 second. It's actually in the Wallace suit. All right. I'm going to pin this to the chat. And I'm also going to go, and after this video is over, I'll put it in the comments. So if you go here to this website, it's the Wallace suit, and you look at the exhibits attached to his complaint, his lawsuit. You'll see everything there. And you can go through it and see exactly what was included. And there are no, thousands of pages of text messages. That's bullshit. All right. One sec, guys. Okay. Right to sue letter is there also. Yes, everything's there. So there's a right to sue letter. There's the precursor. There's the CRD complaint. So you can look at all that. And you can see exactly what the New York Times was working with. So you look through those documents. Don't take my word for it. Look through the documents yourself. Go back to the New York Times article and see, is everything they're saying really in those documents? The answer is fuck no. All right. Nicole Scott here. Thank you for the $10 for filings and real-time news. No problem, man. No problem. Thank you. Thank you for joining me. It's always nice to see recurring viewers here. All right. Now, where were we before I went off on my tangent? Okay. Okay. Legal complaint filed Friday, blah, blah, blah. Okay, any reasonable reader would understand the Times to be reporting on the allegations in the CRD. Moreover, the what really happened phrase, in fact, references the same text that appear in the CRD complaint. Well, no, because you're talking about, I don't know if they used in this exact phrase, but they did say, she said thousands of pages of text messages, and those are not present in that complaint. As plaintiffs themselves note, the fair report analysis looks to whether the gist or sting of the reported facts produce a different effect on the reader than would the CRD complaint. Okay. The footnote here says, in fact, plaintiffs must know this because their counsel has repeatedly affirmed, vouched for, and adopted his client's allegations, presenting as fact the Times engaged in wrongdoing and falsely claiming that the Times had a hand in actually drafting the CRD complaint. Okay. Then they're putting a link to Megyn Kelly there. All right. The gist of the CRD complaint is that Baldoni, Nathan, and Abel used social and traditional media to destroy Lively's reputation. That is, that they engaged in a smear campaign. That is the gist of the article and video too, and as a result, they are fully privileged. Okay, well, I gotta say, you also, I will also afford you the privilege to kiss my ass, but you don't have to exercise it if it's, gross or unethical, which is what you did here, so. For what it's worth, the only text or other information included in the article that do not appear in the CRD complaint undercut rather than endorse Lively's allegations and create no liability for the Times. Okay, some of this case law stuff I skim over a little bit. For example, the article describes how text messages show Baldoni vacillated about the tactics being deployed and was concerned that Abel and Nathan were aggressively attacking Lively using bots, which Abel and Nathan denied doing. The article also notes that Lively told people she worked with, just to pause for a second, your hair care line and all that, not failing because of bots, guys. The bots, they don't have hair. If they use your hair care line and they don't like it, it's not because of bots. So there's some other stuff going on here. We just really don't want to acknowledge that, I guess. All right. The article also notes that Lively told people she worked with that Baldoni and Heath's behavior had improved after new protections were put in place. When you say behavior had improved after new protections put in place, it's basically like, yeah, they decided to do whatever I said and they, couldn't do anything about it after I forced them to sign this document. Or I would blow up the film and they would have to recast me and I wouldn't do any film promotion. Yeah, no, there's nothing shady about that at all, right? Seems pretty cut and dry. Pack it in, guys. That's it. Nothing bad happened. All right. And it includes plaintiff's beliefs that Baldoni, Nathan, and Abel suspected that Lively was using her own public relations team to create bad press about Baldoni. Far from ratifying the CRD complaint, the allegedly unprivileged material published in the article casts plaintiffs in a better light than allegations in the CRD complaint. Okay. More fundamentally, plaintiffs' attempt to extract one sentence from the video and make it some kind of gotcha moment finds no support in the law. Okay, well, that's why I'm here reading these things, because even if, like I said, there's lots of lawyers that'll go over the legal technicalities and stuff like this, but I'm concerned with like this stuff in actual like layperson's opinion, public opinion, how this actually affects people in real life, not just in the courtroom. And it is definitely a gotcha moment. And even if it's not supported by the court, even if this case gets dismissed, I still know what a raging asshole you are. So it served its purpose, to be honest. All right. The purpose of providing immunity to fair and true reports of judicial and official proceedings is to encourage the dissemination of information serving the public interest. Barry versus, I actually don't know who that is, something publishing company. For that reason, the privilege is broadly construed, not analyzed by microscopic word-by-word parsing. Yeah, that's quite a bit different than what's going on here, but sure. No reasonable reader or viewer could miss the fact that the Times was reporting on the CRD complaint. Guys, I think if you're subscribed to the New York Times and you came to the conclusion that maybe something else was going on here, you should probably unsubscribe from them because you're not a reasonable reader by their standard. Got it. Finally, little needs to be said about plaintiffs theorizing that the Times reporting was a conspiracy or collusion with Lively that defeats the privilege. They are wrong. Courts consistently have held that the activity alleged in the FAC, receiving the CRD complaint and communicating with Lively prior to filing, does not, oh god, that word again, vitiate the privilege. Okay. That the Times purportedly gathered information from Lively does not preclude it from invoking the privilege. The FAC should be dismissed with prejudice. Okay. 2, the smear campaign phrase is protected opinion. What else is protected opinion is, well, I think you're garbage, but here we are. The phrase smear campaign is also non-actionable because it's constitutionally protected opinion based on disclosed facts. Specifically, the contents of the text messages quoted in the CRD complaint in which plaintiffs discuss their desire to bury Lively. Plaintiffs' arguments to the contrary are unavailing. Okay. What's going on here? Oh, guys, I don't even know what you're talking about here. I see lots of back and forth, but I have actually no idea what's happening in the chat right now. So, sorry, man. Natalie, thank you for joining us. I appreciate that. All right. Sorry, wrong tab. All right. First, plaintiffs argue that because the article and video reference the text messages the Times reviewed in the course of its reporting, the smear campaign phrase implies the existence of undisclosed facts. But the Times did disclose the facts supporting the smear campaign conclusion. The article and video quote from or summarize those very text messages from the CRD complaint, which support the conclusion that plaintiffs sought to and did harm Lively's reputation using social and traditional media. No. If you take them out of context, maybe, but apparently you had the full context and you chose not to use it. All right. Plaintiffs also claim that a smear campaign is inherently factual, but courts have repeatedly held the opposite. Okay. Okay, so this case that they're citing here says, journalistic smear was no more than rhetorical hyperbole, a vigorous epithet. Beautiful language. Very nice. You're still an asshole. All right. Nor does the language of the article and video accuse them of misconduct on a scale larger than that at issue in the CRD complaint by characterizing the Abel/Nathan operation as a smear machine. Okay. The CRD complaint describes how Nathan was hired to quickly deploy time-tested tactics and tools and support staff like Jed Wallace to change the narrative to benefit Baldoni and harm Lively. Phrases like smear machine or smear campaign aptly and correctly characterize the scale of the misconduct those allegations support. I'm running out of ways to say you're an asshole. All right. 3. Plaintiffs have not plausibly alleged actual malice. What is so notable about plaintiffs' attempts to say that they adequately pleaded actual malice is the jarring lack of reference to any actual factual allegation in the FAC. That is not surprising. The FAC offers only boilerplate allegations and does not identify facts in the Times' possession that should have caused the reporters to doubt the smear campaign allegation. Really? That's just flat out not true, but okay. To the contrary, the CRD complaint contains text after text to and from plaintiffs themselves that establish that Baldoni wanted Lively to be buried and that Nathan acknowledged that we can bury anyone, that Baldoni wanted to use Lively's words against her, or that Wallace and his team hired by Nathan were successful in shifting the impressions towards shining a spotlight on Lively. Plaintiffs do not challenge their authenticity. These texts gave the Times reason to believe there was a smear campaign and no basis for doubting the truth of saying so. Once again, the thousands of pages of text messages that you claim to have gone through would have provided you a basis for doubting the truth. So which one is it? Next, plaintiffs argued that Lively's allegations that plaintiff waged a smear campaign against her is so improbable that it is evidence of actual malice. This claim is baseless. There were no improbable allegations here. The text messages reproduced in the CRD complaint support the existence of a smear campaign. Finally, plaintiffs assert that the Times' multiple requests for comment are somehow evidence of ill will. But this is absurd, particularly given that plaintiffs gave a comment to the Times that it published in full. Plaintiffs have not plausibly alleged actual malice. Okay, so this is mischaracterizing it quite a lot. Multiple requests for comment are somehow evidence of ill will. No, the ill will part of it was, like we said before, the weekend before Christmas, sending them a request late at night, not waiting to see if the others wanted to respond, publishing one statement that you got from somebody, but then also publishing your article before the deadline that you gave these people to respond after giving them less than 24 hours to do so. Again, right before the holidays, when most of these people are on the West Coast, 3 hours behind. So when you said you were going to publish it at noon, that was what, 9 a.m. in California? But you actually published it almost a couple hours early, so that would have been 7-something in the morning. Jesus. Again, you can argue this in court and you might get away with it, fine. But everybody's going to see you for the trash that you are outside of it. The false light claim fails. New York law does not recognize the false light tort, and because this case is governed by New York law, plaintiff's false light claim fails. But even if California law did apply, false light claims are defeated by the same defenses that apply to a defamation claim that is based, as here, on the same publication. Therefore, because the video and article are privileged, contain non-actionable opinion, and because the FAC fails to plausibly allege actual malice, plaintiff's false light claim should be dismissed with prejudice. The tag-along claims fail. Plaintiffs' ham-fisted attempt to salvage their tag-along promissory fraud and implied in fact contract claims also fails. As an initial matter, the emails submitted by the Times in support of its opening are properly incorporated into the complaint because plaintiffs specifically quoted and referred to them in the FAC. More damningly, plaintiffs continue to grossly misrepresent. Oh, you don't want to go there. Grossly misrepresent what Ms. Thuy offered, a deadline for response, which plaintiffs provided, not a promise to hold off publications until noon in exchange for a response. But now everybody's seen your game. You can argue that that's okay legally, but again, from a public opinion standpoint and from a decent human being standpoint, you're kind of a dick. Because both claims depend on that mischaracterization, both fail. I don't think what they said was a mischaracterization. I just think it's maybe possibly not illegal what they did. You know what I mean? And the promissory fraud separately fails because for all of plaintiffs' allegations of purported scrambling, they do not allege in their FAC that they ever intended to provide anything beyond their initial response, nor could they, since the correspondence is devoid of any request for more time. The promissory fraud and contract claims should be dismissed with prejudice. E. Plaintiffs should not be permitted a Fourth Amendment. In the most remarkable display of hubris, how the fuck is that hubris, dude? This is like standard court stuff. In the most remarkable display of hubris, plaintiffs ask this court if it dismisses the FAC to allow them to amend. But plaintiffs have now had 3 bites at the apple, once in California and twice here. They were never actually served with the complaint in California, by the way. So no, not really. That never went forward. They decided to, they let that go, and then they decided to fight it out here. So if you want to talk about mischaracterizing, maybe don't do it in the next paragraph. And yet the FAC still contains, for example, Rule 8 barred group pleading that does not sufficiently differentiate between the conduct of each of the consolidated defendants. The federal rules treatment of amendments is liberal, not laissez-faire. You guys suck. That is particularly so here because amendment would be futile. No amendment can change the fact that the article and video are privileged, that smear campaign is a statement of opinion, that the false light claim fails because it does not exist under New York law, or that the quasi-contract claims are based on gross misrepresentations of the emails. Great. Great. And no amount of spin you put on this can change the fact that you are an asshole. All right. Sorry, I don't mean to point that at their lawyer. I meant to point that at them, but still. Let's see. Brady dismissing complaint with prejudice. In short, not only did plaintiffs wait too long to amend, they also can do nothing to save their claims. Conclusion, for all the reasons set forth above, in the Times opening, the Times respectfully requests, I know. The Times respectfully requests that the court dismiss the First Amendment complaint with prejudice under Rule 12b-6 and grant such other and further relief as the court deems just and proper. All right. Let me make sure I haven't missed anything else. Just give me one sec. Now we're good. Okay. Like I said, my friend Omar is streaming right now. This is what his channel looks right now. Hang on. 1 second. Just tab instead. So he's streaming right now. Blake versus Justin. Baldoni and co-defendant files answers. She's so effed. So if you guys want to know why she's so effed, then let's go find out, shall we? I'm going to join him on his stream briefly. So if you want to hang out with me over there, let's do that. As soon as I end this stream, it'll redirect you over to him. Be sure to put lots of bacon bots in the chat. And I will talk to you guys soon. If any more filings come up, I'll get to them later tonight. But I'm going to go do a jigsaw puzzle and eat dinner at my mom and dad's house. So it'll have to wait, which is not normal for me. Usually I get to it right away. So we'll see. All right. Electronically signed on behalf of assholes. Yeah. All right. Okay. And don't forget to take a look at that CRD complaint and all the links that I sent you. I'll pin the comment in the I'll pin the link in the comments below in this video as well. So, all right, guys, I'll see you in just a second. Okay. Bye. I have to hit the button. Okay. Bye.